Hello, everybody. Welcome back to the fifth session of Morrison Foerster and Nucleate's Advanced Topics in Patent Law course. We are halfway through the course and look forward to continuing these discussions over the next several weeks. Today's session, we will focus on biologics, patent drafting, and IP strategy, and these will be led by Morrison Foerster Associate Meghan Poon. Keep in mind that we welcome your questions during this 1-hour session. Use the Q&A feature, and we'll do our best to answer your questions. If you have any technical difficulties, please use the Q&A feature or contact Nora Moore. If there are topics that you'd like us to cover, please let us know. We're going to be circulating surveys at the end of the session and would appreciate your participation and input so we can get better enhance the classes in the future. And as a reminder, we've had a number of you take advantage of our office hours. Office hours are still available. If you are interested in an initial 30-minute consultation with a MoFo attorney, a patent agent, please send me an email and we'll introduce yourself and we'll get you connected with the right person. And finally, we are actively recruiting patent agents to the firm, and if you're interested, please contact us. With that, Meghan, let's go.
Okay, great. So today I'm talking about a topic that's very near and dear to my heart, biologics, patent drafting, and IP strategy. And as Mike mentioned, he'll be monitoring the comments, but I'm happy to connect with anybody with follow-up questions over LinkedIn or email as well. My contact information is at the end. So biologics is an extremely complex and rapidly evolving technology, and I'm hoping today during the talk I can share with you some of the challenges in terms of protecting biologics, as well as the strategies that we use to protect our clients' most important inventions. Okay, so the talk will have three sections. We'll start out with just a general introduction to biologics. So that'll cover basically what do I mean by biologic and how is that different than other technologies? And again, sort of what challenges are provided by protecting biologics. After that, we'll talk about the different layers of protection and the strategies that we use to claim and protect biologics in patents and patent applications. And then we'll go on to specific prosecution issues for biologic inventions. Okay, so what are biologics? I'm providing just a working definition here. There are a lot of different ways that you can think about it, but one way is just a product that's produced by a living organism or a product that contains a component of a living organism. So, biologics that might come to mind might be gene therapies, cell therapies, antibodies, nucleic acids, all of that sort of thing falls within the realm of biologics. Another way that I sometimes think about biologics is just, other therapeutics other than small molecules. So, everybody's familiar with what a small molecule is, and biologics can be sort of thought of as anything that you administer to a person that's other than that. Another way to think about biologics is the regulatory pathway. So FDA has a separate pathway for approving biologics, which is through the BLA, Biologics Licensing Application, as compared to the small molecules, which go through the new drug application process with FDA. So as I mentioned previously, there are some key differences between biologics and small molecules, and these differences actually really impact our IP strategy. Biologics are more likely to be immunogenic as compared to small molecules, and that's because of the way that biologics are made. So the definition of biologics being that it's something that's made by or a part of a living organism causes them to be more immunogenic when administered to people. So, for example, antibodies, you can't simply administer an antibody that's produced in a mouse to a human without removing the additional immunogenic components. Small molecules, on the other hand, tend to have less of these issues. Biologics also tend to be more often heterogeneous mixtures. So again, that tends to be because of the way that biologics are made. So examples of this are, post-translational modifications of proteins, and so forth. Small molecules, on the other hand, tend to be a lot less heterogeneous, and they can be, more highly purified than biologics themselves. Because of the first two items, the immunogenicity and the heterogeneous mixtures, biologics tend to require more tailored production methods. And by that, I mean, there's not just necessarily a one size fits all. Hey, you want to have a cell therapy, you just go ahead and apply, method X to, purify the cells. You actually tend to require tailored purification methods to the precise biologic that you're planning to administer to a person. On the plus side, biologics tend to be, or can be, more specific to the target. So for example, antibodies are well known for incredible specificity to their antigen. This can be helpful for reducing side effects of biologics compared to small molecules, which can sometimes be less specific and bind to off-target receptors, for example. Because of their size, delivery for biologics can be more challenging. And an example of this is, crossing the blood-brain barrier, which, only allows molecules of a certain size. There are also issues sometimes with half-lives of biologics based upon their size as well. So just to kind of get you thinking about different types of biologics and provide some examples of biologics that have been previously approved, I believe the first approved biologics was the protein insulin, which I think was approved sometime in the 1980s. Antibodies are another good example of biologics, which I think were approved in the 1990s first. Cell therapies have really, come into the fore in terms of biologics, and I think several have been approved now, starting as early as 2017. Nucleic acid is a hot area for biologics, including RNAi, as well as gene therapy vectors, which have both been recently approved. This graph is sort of meant to show the rise of biologics over time. So in dark blue are new molecule entities, which are small molecules. And in that light blue sort of teal color are biologics approvals. And these are the number of approvals of a product each year by the FDA. So as you can see, the first biologics were approved in the 1990s at a very low level, and most of the FDA approved drugs each year were small molecules. But as time has gone on, the relative share of biologic approvals has dramatically increased to represent, about 20% in 2019. So this just really shows how the nature of therapy is changing over time and being more and more driven by biologics. Not just are biologics becoming more dominant in terms of the number of approvals, but actually in terms of the number of dollars and the sales of drugs, biologics really dominate the approved drug landscape. This is a slide showing the top drug sales in 2018 and 2019, and I've put in boxes all of the biologics. So as you can see here, biologics account for 8 out of the top 10 drugs in 2018 and 2019. And most of these biologics are antibodies, with the exception, I think, of Prevnar, which I believe is a vaccine. So that's sort of a primer in terms of what are biologics and what are they not, and sort of getting you thinking about different ways that you can protect biologics and what are the challenges in protecting them. So now we'll go into talking in more detail about the layers and levels of protection for biologics and how we strategize to protect our clients' inventions. So the way we typically think about protecting biologics or really any technology is in terms of sort of core protection, which we term first generation, and then additional generations thereafter. So second, third generation, et cetera. In the blue in the center, that's what I would consider the core first generation protection. And those type of claims are composition claims and method of treatment claims based upon most likely the first approved indication. But what tends to happen over time with development of biologics is that there are additional aspects that are identified of the technology that turn out to be important, both in terms of therapeutic efficacy and delivery, but also present new opportunities to develop IP. And these are the additional generations. So, for example, formulations, methods of production and purification, routes of administration. So for example, can you administer your therapy intravenously versus subcutaneously? Additional specific patient populations. So for example, let's say you develop a biologic and you know that it has sort of anti-tumor effects. You might eventually identify specific patient populations of individuals with solid tumors or brain cancer or different more specific indications, which again can provide a new avenue for protection. Also combination therapies. So typically in the first generation, we try to protect the biologic itself as well as a monotherapy of the biologic, but oftentimes combination therapy can be very effective, both combination of biologics with one another and also biologics, with chemotherapeutics, for example. Additionally, dosage regimen can provide additional second and third generation protection for a newly discovered biologic. This is also important in terms of the length of protection. So having these different layers actually allows extension of the patent lifetime. What I mean by that is, first, if you file your composition or method of treatment patent, you get 20-year patent term starting with the first non-provisional filing. But these additional aspects, which are later discovered, can give rise to later filings, which can extend past that 20-year time frame. And this can be really valuable follow-on protection. So to get more into the nuts and bolts of exactly how we claim and protect biologics, provided some exemplary types of claims for various biologics here. So these are composition of matter claims for proteins. As you can see here, the first claim is an antibody that binds to a particular target. And the antibody comprises CDRs that are recited by specific sequence ID numbers. We'll talk a little bit more about this later in the presentation, but currently, based upon the US standard, really the gold standard for antibody claims tends to be CDRs. And even in certain cases, the claims have to be limited even further than CDRs to VH and VL sequences. Another type of claim could just be a polypeptide comprising a particular amino acid sequence, as shown by the second bullet. Additional types of composition claims that we often present are nucleic acid claims. So a nucleic acid claim could be just a nucleic acid comprising a particular nucleotide sequence, but another way to claim a polypeptide would be by a nucleic acid encoding the amino acid sequence set forth in a particular sequence. We also claim vectors comprising specific nucleic acid sequences as well. So for example, like a gene therapy vector or something like that. We also write claims to cells. So these could be host cells. Another example could be like a CAR T cell claim, and then methods of treatment. So this is, again, we're talking about core protection here. So this would be like a first generation type claim, a method of treating cancer comprising administering a particular antibody. So as I mentioned in the beginning, biologics actually tend to require very specific production methods, and this can be a really valuable avenue for additional IP protection as well. So when you're thinking about how to protect your biologic, you want to think about methods of purification. So have you devised a new order of columns that wasn't previously applied in this context? Particular buffer conditions, certain salt levels, and that kind of a thing. Other methods of cell culture can also be additional ways to protect the biologic, as well as cell culture media. Methods of manufacturing are a third type of method that can be useful in this regard. And this can be extremely important if the method of manufacturing results in a difference in the product per se. So for example, perhaps culturing, perhaps your biologic can really only be produced in a particular type of cell because of a post-translational modification that you either would like to have or would not like to have. Formulations and dosage regimens are another particularly important aspect of protecting biologics, and formulations in particular because they tend to be important for maintaining the structure and stability of large molecules. So perhaps you need a specific excipient to stabilize the antibody or the cell culture formulation, and you want to get a patent on that. The formulation can also be optimized for a route of administration. So for example, intravenous versus subcutaneous administration. pH, buffers, salts, concentration of the active ingredient are all things that you want to think about in terms of whether there might be something that's protectable there. Dosage regimen claims also can provide valuable protection, but when you craft your dosage regimen claims, you want to be very careful to follow the language on the label. So usually these type of claims come up later during product development, close to around the time of approval when you've really settled on a very specific dosage regimen that you're going to use to administer the biologic.
And Megan?
Yes.
Got lots of questions.
Okay.
So, and maybe you're going to get to some of this, and if so, just we can put it off. One, Paul asks, what's the best way to patent an epitope? Is that still possible?
That's a great question. So epitope claims are under a lot of scrutiny, and they're very, very challenging to obtain in the United States based upon current case law. We'll talk a little bit about this, but functional claiming of antibodies is really disfavored in the US. Now, there are certain jurisdictions, including Europe, where you still are able to obtain epitope claims, an antibody that binds to epitope X. So whenever we draft patent applications, we include the information about the epitope, and we do draft those claims. I think when you're thinking about whether to pursue an epitope claim, you really need to think about how much support you have in the application in terms of experimental support. So that means how many antibodies do you have that bind to that epitope? How have you demonstrated that the antibodies bind to the epitope? So, do you have a crystal structure? Is it binning and so forth? And the more information that you have that you can bring to bear, the more possible it is in certain jurisdictions to get an epitope claim, but not as likely in the US right now.
So what about mutations to very particular sequences? So the question is, if this person created a CDR with a single mutation, will that still be covered? How about 10, 100? How do you get coverage for the mutations?
So I think there's two questions here, possibly. So one is whether your CDR claims cover an antibody with a mutation, and then the second is what scope of claims you can get. So in terms of CDR mutations, you can draft a claim to what I would call like a degenerate CDR, meaning, you say that certain amino acids can be, a subset, or it can be anything. Those claims are, slightly stronger from the US perspective in terms of patentability as compared to the epitope claim. Again, it really depends on how much data that you have. So, for example, if you want to claim, just generally a CDR with a mutation and you have no antibodies with mutations to, in that CDR, that's a real uphill battle. If you have a whole, let's say you humanize an antibody and you make a whole ton of different CDR mutations, then, again, you can get protection of a degenerate CDR potentially.
Can you speak a little bit about trade secrets, with respect, you were talking about claims of processes and how do trade secrets interact with biologics and patents?
Yeah. So I think traditionally, companies did protect a lot of the manufacturing via trade secrets, but we're seeing a transition a little bit away from that more recently, and we are seeing a lot more manufacturing type patents. And I think basically what's happened is that, companies have recognized the value of these patents in terms of enforcing against biosimilars and competitors. And so we are seeing that. I think, of course, it's always a sort of case by case decision about whether you keep a manufacturing process that's trade secret or not. But, and that considerations are the sort of typical trade secret considerations, like, will somebody be able to figure out what process you use to make the antibody, or, is it something that you really can keep secret? But we are definitely seeing a trend towards patenting things that would have previously been considered a trade secret, like cell culture media and that kind of a thing.
Another question is, what type of patent do you file to make sure the first generation of your drug doesn't become prior art for the next generation?
Yeah, that's a great question. And that it is definitely a challenge. So you have to think very carefully about exactly what you've enabled and described when you file that first patent application. So the first patent application will become prior art against subsequent filing, and there's no way that you can avoid that. So the only thing that you can do is be very cognizant of that fact and try to tailor your disclosure to keep yourself sort of give yourself room for these subsequent filings. So, you don't want to, for example, in that first filing, say that your antibody can be used for anything if you're only developing it right away for use, for solid tumors, right? So you might want to limit your disclosure to using the antibody for treating solid tumors. And then if you find out that your antibody is also good for treating, leukemia, well, your first case didn't disclose that, so you're free of the prior art. So it's really a matter of tailoring the disclosure of your patent application to what's really supported by the data and what you're likely to get, and leaving yourself the opportunity for these additional filings later.
So there's also a question, and I think we have to parse this one out a little. It's asking, do second generation strategies, formulations, administrations, etc., face, and this is what I think we have to parse out. The Andrew writes obviousness type double patenting. I think we need to parse out for the class the difference between obviousness type double patenting and just plain old obviousness.
Right.
And you can go through the difference.
Sure. So as we talked about, your first generation patents and patent applications will become prior art for your second and subsequent filings, and that's something that you have to navigate. And so you have to establish that your second generation claims are non-obvious over the disclosure of your first set of claims. In the United States, and that sort of goes for basically every jurisdiction. In the United States, though, there's also a rule against obviousness type double patenting. And obviousness type double patenting is based upon overlap of claims. So are your claims of your second patent distinct from the claims of your first patent, regardless of the specification, which is really a different inquiry, right? Because the claims are just a small part of the first filing. And so you have to establish that as well. And obviousness type double patenting also has an interesting wrinkle in that you can file a terminal disclaimer over your previous patent, right? So if you are not able to establish that your second generation formulation claims are patentably distinct from your first generation claims, you can file a terminal disclaimer in the United States, but that'll reduce the term. So we really try not to do that because, as we talked about, one of the key features of these second and third generation cases is that you're able to extend the patent coverage of your product over time. So you want to avoid having to do that.
And there's just that one sort of minor, it's a fairly major, requirement in order to, file this terminal disclaimer. Both patents have to, Megan?
They have to be co-owned, right?
Exactly.
So, and that is a whole, I don't know if we have time for it today, but that's a whole separate can of worms in terms of, licensing patents and, you have to be really careful when you file a terminal disclaimer. So that's highly, again, really disfavored in these circumstances.
That's great. Okay. No more questions for now.
Okay, great.
These are great questions, by the way, folks.
Yeah, it's great. Okay, so one piece of protection that we haven't talked about, which is really interesting to think about, is what I call platform technology. And platform technology has the potential to be, extremely valuable in terms of enforcement against other innovators. And the types of things that I consider platform technology would be like mutations that can be applied across multiple different proteins and antibodies. So for example, like an FC modification that affects FC effector function. Methods for production that are universally applicable. So the Eigibility patents are an example here, which were directed to methods of humanization. So if you get a patent that covers a method for humanizing an antibody, potentially this can really stop competitors even developing, antibodies to different targets, right? Which can be a tremendous amount of value. Methods for identifying lead candidates are also a platform technology that can be very valuable to companies. And lately, what we've been seeing is a ton of development in terms of AI methods that sort of combined with wet lab techniques. So using AI to identify a particular lead, structure, sequence, or certain lead characteristics that then are, validated in the wet lab or, further refined in the wet lab as well. Methods of treatment and companion diagnostics are also a key piece of the protection puzzle for biologics. Methods of treatment can also be based upon a marker or a genotype. Here, again, you want to think about matching the claims with the label. So if your label says that the patient needs to be HER2 positive, well, then it's likely worthwhile to pursue a patent claim, to methods of treating individuals that are HER2 positive. Again, sub-patient populations, you can even think of like sub-patient populations, all of the different layers. So, you can have a solid tumor claim, you can have treating bladder cancer, you could have treating, a specific type of bladder cancer and so forth. Diagnostic methods is another avenue, and in particular, when those diagnostic methods are companion diagnostics. So, as a part of your therapy, do you need to determine whether or not the patient expresses a particular protein? Is that necessary for the therapy to be effective? Also methods of treatment using a particular route of administration. Okay, so on to specific prosecution issues for biologics. The first item that we'll talk about today is subject matter eligibility. And I think there have already been some presentations covering this, but I want to talk more specifically about how this issue impacts biologic patent protection. I put up the legal standard here, which is that any new and useful process, machine, manufacture, or composition of matter can be patented. So as you'll notice, nowhere in the statute are any real exceptions, but the case law has evolved to create certain what we call judicial exceptions. And these are based upon the concern that we don't want innovators to tie up all uses of a foundational principle. The purpose of patent law from a policy perspective is to enable innovation and further development. So if somebody is able to patent something that's so foundational that no one else can develop anything else new, then that's going contrary to the purpose of patent law. So the judicial exceptions are natural phenomenon, which includes natural products. And I'll talk more about some specific examples of this as well. Abstract ideas, those include algorithms and software, formula, that kind of thing. And laws of nature, which are correlations that occur in a natural setting. I'll pause and say here that this is really a US patent law issue. Certain other countries are beginning to develop their own, similar laws, but really the most important jurisdiction that has this law is the United States, and it's not nearly as big of an issue in other jurisdictions.
Oh, Megan?
Yes.
We got another question.
Great.
So it says, if an off-label use for a biological is employed in a foreign country, and this method of treatment is not patented initially, could it be protected? Is it novel? So I think they're asking if, someone uses a drug for an off-label use. I don't think the foreign country aspect of it matters, but if it somehow gets used for off-label use.
So that is a major downside of those sort of method of treatment claims. We call that skinny labeling. So that's, basically the label may not recite all of the possible uses of the antibody. And if your claims don't cover the use that someone else is using your product for, if you've got method of treating X, then someone uses it for Y, then you tend to be out of luck.
Okay.
So, just think about that, I guess, in terms of your strategy, right? Think about all of the potential uses, and you want to make sure that you pursue claims, ideally, that are broad enough to cover the various uses of your product, as well as having, again, this is why we think about all of the different layers and the composition layers, the formulation, and so forth. So hopefully you can sort of get coverage of your product even if people are using it off-label. You've got those composition of matter patents, or you've got that formulation patent that can still cover. Okay, so in terms of subject matter eligibility, there are issues with composition claims and then also issues with method type claims. So naturally occurring protein and DNA sequences can be considered a product of nature and may not be patentable. Whereas, for example, cDNA is patent eligible. Isolated and recombinant, just tagging that on is most likely not enough. So for example, insulin, can you get a patent on the amino acid sequence of, insulin? No, I mean, not only there's a prior art issue here as well, but just in general, no, because that's not, that is a product of nature. And just saying isolated insulin is also probably not going to be enough. But the good news is that there tend to be modifications required to most natural products in order to make them appropriate therapeutics. So for example, do you need to append something on the end of your protein or nucleic acid so that it can be detected, or so that the half-life can be extended? Or maybe you have a nucleic acid and you want to incorporate nuclease resistant base pairs so that the nucleic acid won't be degraded by a cell. Then again, that takes you out of the naturally occurring product realm. So all of those small differences are potential ways to avoid the subject matter eligibility trap for composition type claims. Method of treatment claims, or method claims, sorry, provide additional issues. So diagnostics may be considered a natural law under current United States law. But we've seen some movement, at least at the federal circuit level, which suggests that reformatting diagnosis claims as treatment claims can be effective. So in other words, let's say your technology is that once you know that somebody has a particular marker, then they will be responsive to your therapy. Rather than having a method of diagnosing X by detecting Y, you can reformat that type of a claim into a method of treatment based upon the particular biomarker. So I sort of alluded to this earlier, and the next topic is the written description standard, which has really become a bit of a thorny issue, and in particular in the United States. So in order to show invention, a patentee has to convey that it had possession of the claim subject matter as of the filing date. And again, this is really a US law, although there are some corresponding laws in other jurisdictions as well. So for claims to a genus, a patentee has to disclose a representative number of species that fall within the scope of the genus, or structural features common to the member of the genus, so that one of ordinary skill in the art can visualize or recognize the members of the genus. So where written description really comes in is when you want to pursue broader genus claims, and the question is, do you have enough written support in your application in order to get the genus claims? So there have been a whole host of recent case law decisions in this realm that have sort of raised the bar on functional claims. And I talked about this when the question about epitope claiming came up. So Amgen Sanofi in 2017, the federal circuit reversed a district court case finding an antibody epitope claim adequately described based upon description of the antibody. And I won't read this claim to you, but essentially it's just an epitope claim. And I'll say that in this particular patent application, there were a lot of antibodies disclosed, and there was a lot of information about the individual, like the specifics of the individual antibodies. I believe it was on the order of hundreds of antibodies were disclosed in this application. Yet the federal circuit found the claims invalid. So this has really further limited the viability of functional claiming for biologics in the US. This has also been followed by the recent Juno versus Kite case, which was sort of similar, having to do with CAR T cells, and sort of decided based upon the generic claiming of the SCFV, which is an antibody piece. Interestingly, however, the case was remanded. The jury found that the patent was valid and there was adequate written description, But then back up on appeal, the Federal Circuit has found the claims invalid for lack of enablement. And this, altogether basically shows that there's a heightened standard both for written description and enablement of functional claims, in particular in the biologics space. So how do we deal with this, and how do we think about establishing written description and sort of try to get the maximum amount of protection in this space? For genus claims, that really the key is the data in the specification, and thinking about how many species you've disclosed and exactly what the properties are of those. You should also consider whether there's a functional relationship between the function and the structure. So, is there a particular way that your antibody is binding to its epitope? And, can you describe that adequately in the specification? And then also just discussing the detailed description as well. So even if you don't have examples, you can certainly describe how your biologic works in the specification to try to provide adequate written support.
So Meghan?
Yes.
There's a question on what do you mean by enablement? Maybe you can describe that.
Yes, I think that's next, actually. So let me, let's put that on hold, and I'm going to come to that in just a minute. I think we've only got a few minutes left, but I think we'll get it. Okay. Okay, so this is basically what I just mentioned. So how do you provide adequate written description? Key is working examples, description of the actual reduction to practice. Functional claims do present a significant issue. You want to think about the different levels of description to provide flexibility. So for example, drafting your, you've got your epitope claims, you've got the CDR claims, the VHVL claims. Maybe you can craft some degenerate sequences as well, so that you've sort of got all of the different layers there within your application. Okay, so then the next sort of the partner to written description under US law is enablement, which is also having to do with the amount of disclosure that's in the application. So the enablement standard is that the specification has to teach one of ordinary skill in the art how to make and use the claimed invention without undue experimentation. And I put here a bullet which is very important, and that's the fact that some experimentation may be required doesn't mean that the patent isn't enabled. So you don't have to spell out like every single way to make something that falls within the scope of your claims. It's okay to have a little bit of experimentation, but the question is always, is that experimentation undue? And again, based upon the current status of case law, the threshold is becoming higher and higher. So you have to provide more and more disclosure around how to make and use something in order to meet the enablement standard. These are the WANS factors, which are the ways that the USPTO or courts decide whether experimentation is undue. And I've highlighted really what the key factors are. So the first is the breadth of the claim. So oftentimes when in both written description and enablement, a key item is, you're claiming the whole world, but you really only disclose one little corner of the world, and you're really not entitled to that whole scope. The second is the nature of the invention. And what that means is, is this a very complex invention? Is it a simple invention? Which sort of feeds into some of the other factors. So biologics tend to be a more complicated inventions, which raises the requirement to enable claims. Another one of the key inquiries for enablement is a level of predictability in the art. And biologic inventions are notoriously unpredictable. Now, on the one hand, that actually can be a good thing in terms of IP protection, because the unpredictability can lead into arguments of non-obviousness. So, how it's unpredictable whether a particular drug will work to treat a particular cancer. You just don't know until you try. Well, that's a great non-obviousness argument. It's not a great enablement argument, because the examiner or the court can come back and say, well, you've only shown that this drug works to treat these 3 diseases. Why should you be enabled? Why are you enabled for treating any old thing? The third bolded is the key that we've been really talking a lot about today, which is the existence of working examples. So it's very important to have working examples in your specifications to show that the claims are enabled. Although I will say it's not a statutory requirement. You can file a patent application without working examples, and you can file it with what we call prophetic examples. But that tends to be more difficult to obtain patent protection for those types of applications, especially in the biologics realm. So post-filing evidence. So you actually can use post-filing information to show that the claims are enabled. And the post-filing evidence that you can present is limited to the arguments or evidence that was produced using methods at the time that the application was filed. So in other words, you can say, I used the methods that were available when the application was filed, but after, and here, voila, I've shown it worked. And this is available under the United States, and we do this from time to time for our clients. One big caveat here, though, is, again, this is a very US specific rule, and in many countries, you are not allowed to use post-filing evidence to show that your claims are enabled. So when you're thinking in terms of your IP strategy, should I file now? Should I wait for the data? While in the US, you can present that post-filing data, in many countries you cannot. So it's a major risk. You can present this in a couple forms. One is an affidavit. This is basically a declaration by the inventor that can provide that kind of post-filing data. Hey, we used the methods that were disclosed in the specification, and voila, the invention works exactly how we described. Another possibility, which I've used with some success, is references, actually. So you can use references to show that, that a particular method was available. Again, you don't necessarily want to be in the position of having to rely on references or affidavits to enable your application. So, probably the advice here is a pinch of prevention is worth a pound of cure. You want to try to put in as much disclosure in your application to prevent having to go down these roads, but it is certainly possible. Okay, so how do you enable a biologics application? So there is a higher threshold for biologics applications as compared to more predictable art. So for example, software, mechanical type inventions tend to have much lower threshold for enablement. Maybe in those technologies, you can get away with, having few or no working examples. As I mentioned, the unpredictability of biologics is a double-edged sword. It can be very, very helpful for non-obviousness arguments, but that's a problem when it comes to enablement. So when you're prosecuting and when you're trying to get your patent from USPTO, you need to be very careful about the types of arguments that you make, because if you argue too much that, this application is enabled because, of course, one of ordinary skill in the art knew how to do this when the application was filed, then the examiner can come back and say, okay, well, then tell me why your invention's not obvious. So it's a fine line to walk. highly recommend a fulsome description of how to make the biologic. I can tell horror stories about applications that were filed when someone who drafted the application and thought, I don't need to describe how to make X because everybody knows how to purify a protein. Sometimes examiners or courts don't agree with that, so it's always better to spell out the techniques that you use rather than having to say later after the fact, oh, this is common knowledge in the art, because you just don't know how a court or a patent examiner is going to look at your specification. For biologics, you often need data showing efficacy in at least a cell line or an animal model for treatment claims. And this really has to do with the unpredictable nature of biologics inventions. So, oftentimes just saying that that a certain target is involved in a certain disease, if you don't have any data that sort of connects the dots and says, yes, and this RNAi actually works in mice or in cell culture, it can be difficult to overcome an enablement rejection. Okay, I think I don't have the timer on me, but I think I'm up on time, but I'm happy to take questions as well.
Now we've got 8 minutes, Megan.
Oh, okay, great.
Now we've got a few questions that I haven't gotten to. Let's a couple on prophetic examples. So in which cases are prophetic examples acceptable, if ever, for biologics patent applications? And then what happens if the prophetic example is found not to be working? Could that be used against you in some sort of enablement of the application in a litigation context?
Yeah, interesting. So, prophetic examples, I think, are of limited value. Where they really are helpful is when you are about to do some experiments and you just don't have the data when you file the application. And then that way you can argue during prosecution, hey, we anticipated exactly how this was going to work. And then you can bring in the data and you say, yes, and it worked exactly as we said it did. So sort of like planting that seed to have the basis to present the post-filing data. And that can actually even be helpful in countries where they have where they really don't allow post-filing data. If you at least have a prophetic example, sometimes they'll let you get it in because you can say, basically the experiments were contemplated and they were, already pretty much done. I haven't seen any examples where having a prophetic example comes back to haunt you, but keep in mind that a prophetic example isn't, at least the way that I've drafted them and seen them drafted, it doesn't include prophetic data. So you don't say and usually you don't even predict what the data is. You would just say, here are the experiments that we're doing, or here's what you can do to test and confirm that this works. You don't want to say, and this example shows that the therapy, is successful to treat cancer or something like that. That's not, that hasn't been proven. So you wouldn't want to put that in your patent application.
I think the one way that you can run into problem is to submit data, post-filing data in a patent application. Remember, you cannot add new subject matter, so you need to submit a declaration from a scientist or an inventor on the patent application. And those statements get scrutinized in litigation. So we really encourage our patent practitioners, our patent agents and patent attorneys to get a litigator involved at that stage to make sure they vet the declaration, because that is precisely where the litigation is going to end up is what did the declarant say? Because often that's the key to getting the claims allowed. The examiner reads the declaration, says, okay, I agree with it, and allows the claims. So that's the key point. So that's often the focus of litigation.
Yeah, exactly. And that's that, to your point, Mike, that's really why you want to try to put in as much in the specification that you can, so you don't have to rely on declarations outside of the specification if you can avoid it.
So one follow-up on the prophetic, Megan, is what do you do in the event that you're out of money and you can't do the experiments? What should you try to do to beef up that patent application to put it in the best place it possibly can be?
Yeah, I mean, you can still rely on, other publications, right, and other information outside of the specification to sort of bootstrap, what you've got. So, and you can also kind of like try to draft your specification in such a way that you can like make all of the logical links. So, this worked over here, so it should work over here. And you kind of can provide the basis for those kind of arguments, even if you don't have the data. But it is a challenge if you're not able to get the data.
One strategy that sometimes gets taken at this stage is, you file your provisional application, you got 12 months to file your full utility application, and you just don't have the data. You can file an application in the United States and decide, okay, I'm just going to give up on foreign rights. I'm not going to file outside the U.S. just because U.S. protection really is often the most valuable. And then file a request for non-publication, so that application doesn't publish. Keep it secret, and then file a continuation in part with the new data when you finally get the data. You get the funding and whatnot. So
Yeah.
That's one way to put yourself in a better position.
That's a good point. And another way, of course, is keeping in mind, even if you don't file a request and not publish, you get another bite at the apple as long as you file another provisional application, within 18 months of the first. So before the first case publishes. So a lot of times, we keep that publication data like very close in mind, and we'll file an additional application to sort of, supplement and go after additional features with more data potentially.
So we've got 2 minutes for one final question. And this is, can you speak about some of the carry-on protection methods that are device-centric? For example, insulin injection pens. How do they dovetail with biological patents?
It's all part of the strategy. Yeah, exactly. So when you think about a biologics product, you want to think about it from all of the various angles. So, sort of from development to like the formulation, what's in the drug, how it's delivered, what it's delivered, all of that. So definitely, like a good example would be like an antibody that's like subcutaneously delivered. So, you can get an antibody patent, you get a subcutaneous, patch, including the antibody. So it's definitely something, that can be pursued. The only thing that you want to keep in mind in terms of like that kind of follow-on protection is there's always going to be an obviousness issue that you'll have to confront. So, you want to think about what are your best non-obviousness arguments. Is it really just, I had a drug that, was known to work, and it was known to be, suitable for injection. And now I'm just saying this is a syringe that's used to inject the drug, right? Versus like, maybe it's a syringe that administers the drug at like a certain frequency, right? Which maybe that's not obvious. So I think that's like the major pitfall for those sort of follow-on inventions.
Yeah. That's great, Megan. Great talk today. Great questions from the audience. We'll see everybody next week. Thanks very much.